My brother showed up at my door at midnight holding a folder and said, "I need you to look at what Dad left out of the will." The knock came at 12:08 a.m. I know the exact time because I had been awake, sitting at my kitchen table with a glass of water and my father's obituary printout in front of me, trying to write a thank you note to the pastor who had officiated the funeral and failing at every sentence. My father had been buried 11 days earlier. I was still at the stage of grief where ordinary tasks require extraordinary concentration, where even making coffee feels like a procedure that needs to be looked up. So when the knock came, I was already awake, already at the table, and I opened the door to find my brother Clement standing on my front steps in a jacket he had clearly pulled on over his pajamas, and holding a manila folder against his chest, the way you hold something you are afraid of dropping. His face looked the way our fathers had looked in the hospital in those last days. Not frightened exactly, but stripped of its usual surface, down to something rawer underneath. I had not seen Clement look like that since we were children. He said, "I need you to look at what Dad left out of the will." I stepped back from the door without answering, because there was nothing to say yet, and he came inside, and we sat at the kitchen table where my thank you note was still unfinished, and he opened the folder, and my father's death became something more complicated than I had understood it to be. I had been managing my father's affairs for 3 years before he died. Not officially. That title went to my stepmother, Renata, aunt who had been married to him for 9 years, and who had, from the beginning of that marriage, positioned herself as the most competent person in any room she occupied. But practically, operationally, it was me who drove my father to his cardiology appointments when Renata was unavailable, which became increasingly often. It was me who organized his medication schedule after his second cardiac event in the spring 2 years prior, who cross-referenced the pharmacy instructions with the cardiologist's notes, and built a laminated chart that lived on his refrigerator. It was me who handled the insurance paperwork for his hospitalizations, who sat across from the hospital administrator, a patient woman named Bridget Osei, who processed everything with tireless efficiency and translated the billing codes into plain language for my father. All who was sharp about most things, but had always found medical bureaucracy opaque. My father, Gerald Fontaine, was 74 when he died. He was a retired civil engineer who had spent 31 years designing drainage infrastructure for the city, unglamorous work that he described as keeping other people dry, and who in retirement had taken up woodworking with the focused intensity he brought to everything. His workshop smelled like cedar and machine oil, and was the place where, in the last years of his life, he seemed most fully himself. He had 2 children from his first marriage, me, Audra, 39, a high school history teacher, and Clement, 36, a project manager at a logistics firm. He had been married to our mother for 18 years before she died of cancer when Clement was 11. He met Renata 7 years after that. Renata Fontaine was 61, 12 years younger than my father, and she had worked in property management before their marriage and continued to manage several residential units she co-owned with a business partner throughout the marriage. She was organized, presentable, and relentlessly practical, which my father found attractive in the way that men who have been alone for a long time sometimes. Now I told myself this was uncharitable. I told myself that practical people love practically, and that what mattered was whether she was kind to him, and she was kind to him, in visible and consistent ways that I could not dismiss. She remembered his medical appointments. She cooked the low-sodium meals his cardiologist required. She attended his granddaughter's school recitals. I had a child from a previous relationship, a daughter named Willa who adored her grandfather, with the kind of patient engagement that suggested genuine affection rather than performance. I accepted Renata. I was never entirely comfortable with her. I believed the discomfort was my problem. In the folder Clement put on my kitchen table at 12:08 a.m., 11 days after our father's funeral, on was a document that suggested my discomfort had been information I had failed to read correctly. The folder contained 3 things. The first was a copy of the will, as read by our father's attorney, a version I had already seen, a straightforward document that left the family home to Renata outright, divided a modest investment account equally between Clement and me, left Renata as the primary beneficiary of his life insurance policy, and included a small trust for Willa to be accessed at 18. The second item was a letter, handwritten on my father's stationery, in handwriting that was unambiguously his, but shakier than I remembered from recent years, dated 8 months before his death. I will not reproduce the full letter here because parts of it are still too private for that. But its essential content was this. My father wrote that he had concerns about a revision to his will made 6 months prior. a revision he had signed, but which he felt, in retrospect, he had not fully understood at the time of signing, and that he wanted the original will, executed 4 years into his marriage to Renata, to be the controlling document. He named Clement and me as the intended recipients of this letter. He said he had given a copy to his attorney, and that if we were reading this letter without having received communication from the attorney, we should contact him directly. The attorney's name was written at the bottom, Harland Pugh, with a phone number. The third item in the folder was a printout of a property transfer deed, filed with the county recorder's office 7 months before my father's death. Into transferring ownership of a rental property my father had purchased before his marriage to Renata, a duplex in the east part of the city, fully paid off, worth approximately $340,000. To Renata Fontaine, as sole owner, as a gift. My father's signature was on the deed. So was a notary stamp. Clement had found the deed through the county recorder's public database, which he had started searching, he told me quietly, after Renata mentioned casually at the post-funeral reception that she would be reviewing all property holdings in the coming weeks. I sat at my kitchen table for a long time after Clement finished explaining. The thank you note was still on the table. The glass of water had gone warm. I picked up the handwritten letter and read it again, slowly, matching the words to my father's voice. Finding him in the phrasing, the slightly formal sentence structure he used when he was being deliberate, the way he capitalized certain words for emphasis, the closing that was just his name, Gerald, without any of the usual warmth, because he was writing a document rather than a letter. It was unmistakably him. It was also a man who had been worried enough about something to write it down and make sure his children could find it. That detail, the planning of it, the careful provision, sat in me like a stone. I looked at Clement. He looked like he had not slept. I asked him when he had found the property deed. He said 4 days ago. I asked why he had waited 4 days. He said he needed to make sure he was reading it correctly, that he had not wanted to bring me something that turned out to be nothing. I said it was not nothing. When he said he knew. We sat together in the kitchen until nearly 2 a.m, going through the folder item by item, and when he finally left, I stood at the closed door for a moment and felt the specific grief of understanding that someone you have lost was also, in their final months, quietly afraid of something they did not want to tell you directly. My father had not called me. He had written a letter. That gap told me everything about what he thought he was dealing with. The next morning, I called Harland Pugh at 8:45. He answered immediately, which meant he had been expecting the call, which meant the letter had done its work. And Harland Pugh had been practicing estate law for 28 years and had a voice that was professionally neutral in the way that experienced attorneys develop when they know they are about to say something significant. He confirmed that he had received a copy of the handwritten letter from my father approximately 8 months ago. He confirmed that my father had expressed concerns about the will revision made 6 months prior to that. He said that the revision, which he had not drafted, which had been brought to him as a completed document for filing by Renata, had modified the distribution of the investment account, reducing Clement's and my shares by $45,000 each and redirecting those amounts to Renata. He said my father had signed the revision in his office, in his presence, and that at the time of signing he had appeared lucid. He said that my father's subsequent letter expressing reservations had complicated things, and that he had been waiting to see whether Renata would disclose the revision voluntarily at the will reading. She had not. She had allowed the original distribution to be read as though the revision did not exist. Harland Pugh said he considered this a significant problem. He said he had the letter on file and was prepared to cooperate with any legal process that followed. He asked if I had retained an attorney. I said, not yet. He said I should do so soon. He gave me the name of a probate litigator he respected. Farida Okonkwo, 16 years in estate and probate law, a woman he described as thorough and composed. I called her before 10 o'clock. Farida Okonkwo's office was on the 14th floor of a building downtown that had too much glass and not enough shade, and she was already reviewing the documents Harland Pugh had faxed her when I arrived for our first meeting at 2 p.m. She was a compact, precise woman who wore reading glasses on a chain and who moved through information the way surgeons move through a procedure. With economy, without hesitation, without visible reaction to things that would cause visible reaction in most people. She looked at the letter, the property deed, the will revision, and the original will, and she asked me 7 questions. She asked whether my father had any documented cognitive decline in the period before signing the revision. She asked whether Renata had been present at the signing. She asked whether I had any other communications from my father expressing concern or confusion about financial matters. She asked whether the property transferred by deed had been mentioned in any version of the will. She asked whether Renata had made any other transfers or transactions involving my father's assets in the 18 months before his death. She asked whether my father had a separate physician he trusted who could speak to his condition during the relevant period. She asked whether my father had ever told me directly that he was worried about anything. I answered what I could answer and told her I would need to find the rest. She said, "The letter is significant. Undue influence cases are difficult to prove without contemporaneous documentation, but a handwritten letter expressing concern about a specific transaction, in a man with a cardiac history who was under the care of someone with access to his affairs, is contemporaneous documentation. We need to know what else exists." I noticed she said we. I went home and started looking. The search took 10 days and covered more ground than I expected. The first thing I found was in my father's desk, which Renata had offered to help me sort through, and which I had declined in a way that was polite enough to avoid conflict, but firm enough to ensure I was the one who went through it. In the bottom drawer, in a manila envelope labeled Tax 2021, I found a letter from my father's cardiologist, Dr. Namdi Achebe, dated 14 months before his death, noting that my father had experienced 2 episodes of confusion following a medication adjustment and that his cognitive function should be monitored. The letter was addressed to my father. He had filed it with his tax documents, which was not where it belonged, which told me his organizational systems had been slipping. I photographed it and sent it to Farida. The second thing I found was through a conversation with my father's neighbor, a retired postal worker named Everard Holt, who had known my father for 20 years, and who, when I stopped by to thank him for the sympathy card he had sent, told me unprompted that in the last year of my father's life he had sometimes seemed confused when they talked over the fence, repeating questions he had asked earlier in the same conversation, expressing uncertainty about what day it was. Everard said he had assumed it was normal aging. He said he had not mentioned it because he had not wanted to overstep. I asked if he would be willing to write down what he had observed. He said yes, without hesitation. His written statement was 5 handwritten pages, specific and dated to the extent his memory allowed, and it corroborated the timeline Farida was building. The third thing was harder to find and harder to hold. Clement had been doing his own searching, methodically, and without telling me until he had something concrete to bring. He found it by pulling my father's bank records from the joint account he had shared with Renata, which he obtained legally through the probate process as an interested party. Over an 18-month period ending 2 months before my father's death, there had been 23 withdrawals from the joint account, ranging from $800 to $4,200, made at branches of a bank in the eastern part of the city, near the duplex that had been transferred to Renata's sole ownership. On days when, according to Clement's review of my father's medical appointment calendar, my father had not been well enough to drive. The withdrawals were not enormous individually. Together, they added up to $38,000. Clement put this information in a spreadsheet with dates, amounts, and cross-references to the medical calendar, and emailed it to Farida with a subject line that said, "Additional findings." Farida forwarded it to a forensic accountant she worked with regularly, a man named Dr. Tobias Renner, who had 15 years in financial forensics and who prepared a preliminary report within a week, indicating that the withdrawal pattern was inconsistent with my father's documented activity in prior years, and suggested systematic external access to the account. The report used the phrase "consistent with financial exploitation of a vulnerable adult." I read that phrase at my kitchen table on a Friday morning, with Willa's crayon drawings still stuck to the refrigerator behind me, and my father's laminated medication chart that I had not yet been able to take down, and I felt something settle into place in me that was not peace and was not anger, but was some third thing. A kind of terrible clarity. Farida contacted Adult Protective Services, which assigned a senior investigator named Delia Marchetti, who had 11 years with the unit and who arrived at my house with a notepad and a recorder and the specific manner of someone who has heard difficult things many times and has learned to let people take the time they need to say them. She reviewed the documents Farida had assembled and conducted her own interviews, including with Harland Pugh and with Dr. Achebe, who confirmed in a formal statement that my father's cognitive capacity had been declining in the 18 months before his death, and that the medication adjustment period documented in the letter I found had represented a particular window of vulnerability. She interviewed Everard Holt. She requested the bank records directly and confirmed the withdrawal pattern. She also, and this was the piece I had not anticipated, contacted Renata directly. But Renata's response to Delia Marchetti's inquiry was to retain a defense attorney named Gregory Solari within 48 hours, which is what people do when they know the question is coming and have already prepared for it. Gregory Solari's involvement confirmed in the particular language of legal maneuvering that there was something to defend against. Farida called me when she heard Solari was involved and said, "She knows." She said it without particular inflection, the way you state a fact that changes the operational reality without changing the underlying truth. I said I knew. We discussed next steps. There were many. The crisis arrived in the form of a letter from Gregory Solari, sent to Farida, asserting that Renata intended to file a claim against the estate for additional assets she alleged my father had promised her verbally, but including a portion of the investment account above what the will had designated. The letter was dated a Friday. Farida called me when she received it and said we needed to meet within 24 hours. I drove to her office on a Saturday morning with Clement, and we sat across from her as she explained Renata's counterclaim, if filed and accepted, could tie up the estate for 2 years and could potentially succeed if she had any documentation of the alleged verbal promises. The question was whether she did. Farida said, "If she has anything in writing, texts, emails, notes, we need to know before she produces it in a courtroom." My hands were cold. Clement was very still beside me. I thought about my father's workshop, about the cedar smell, about the laminated medication chart on the refrigerator. I thought about him writing that letter alone, in handwriting that had gotten shaky, trying to leave us a trail. I asked Farida what we needed to do. She said, "We go on offense. We file the undue influence challenge formally. We move to freeze the transferred property pending investigation, and we get Dr. Achebe on record formally." She said it clearly, without drama, as if she had been here before. Because she had been here before, many times, and that steadiness was the thing I needed most in that room. I said, "Do it." Clement nodded. Farida opened her laptop and started typing. The formal challenge to the estate was filed on a Monday. Farida's filing included the handwritten letter, the cardiologist's statement, Delia Marchetti's investigative findings, Dr. Renner's forensic financial report, and Everard Holt's written statement. It named the property transfer and the will revision as transactions requiring judicial review on the grounds of undue influence and potential exploitation of a vulnerable adult. The probate court issued a temporary freeze on the transferred property within 48 hours. Renata's attorney filed an objection the same day. The objection was denied pending the full hearing. Delia Marchetti's APS investigation was referred to the County District Attorney's Financial Crimes Unit, which assigned a deputy DA named Philip Ease, who had prosecuted 8 elder financial exploitation cases in the prior 5 years, and who requested a meeting with Farida within a week of receiving the referral. I did not attend that meeting. Farida attended and called me afterward and said, without being specific, that the DA's interest was serious. That was enough. Renata did not know yet how serious it was becoming, because Renata's attorney was focused on the civil probate fight and had not, as far as we could determine, anticipated that the pattern Clement had documented in the bank records would rise to the level of criminal referral. That miscalculation was Renata's most consequential mistake, and she had made it because she had spent 9 years operating in an environment where the people around her trusted her enough not to look closely. Clement and I had been part of that environment. We were not anymore. The probate hearing took place over 2 days in late autumn. Harland Pugh testified about my father's letter and about the circumstances of the will revision signing, including his observation that my father had seemed uncertain at several points during the signing and had asked to have provisions reread multiple times. Dr. Nnamdi Achebe testified via written declaration about the cognitive decline documented in my father's records, specifically the 14-month period preceding his death. Dr. Renner presented the forensic financial analysis, walking the probate judge through the withdrawal pattern and its inconsistency with my father's established financial behavior. Everard Holt testified in person, in a short-sleeved shirt and the careful manner of a man who understood the gravity of what he had been asked to do and intended to do it correctly. Delia Marchetti submitted her investigative report. Farida presented all of it in the methodical, unhurried way she did everything, not giving the judge room to absorb each piece before moving to the next. Gregory Solari cross-examined every witness, which was his job and which he did competently. But competence requires something to work with, and the documentation Farida had assembled did not have the kinds of gaps that cross-examination can exploit. The probate judge was a woman named Judge Vivienne Osei-Kwame, who had been on the bench for 14 years and who asked precise, substantive questions throughout both days. On the second day, at approximately 4:15 in the afternoon, she issued her preliminary ruling. The will revision was invalidated on the grounds of undue influence. The original will was reinstated as the controlling document, and the property transfer was referred for additional review pending the DA's investigation. Renata's counterclaim was dismissed. The investment account was to be distributed according to the original will, without reduction. I was sitting beside Clement in the courtroom when Judge Osei Kwame read the ruling. I had been holding my phone with both hands, not looking at it, just holding it, and when the judge finished, I put it in my bag and looked at my hands and thought about my father writing that letter in his shaky handwriting and putting a copy in an envelope for Harland Pugh and filing the letter in a drawer where he knew I would eventually look. He had known someone would look. He had just needed to make it possible to find. Clement put his hand briefly on my arm and then took it away because we are not a family that sustains physical contact easily. And that small, familiar restraint made my throat tighten in a way the ruling itself had not. Gregory Solari spoke briefly to Farida in the corridor. I did not hear what was said. Renata was not in the courtroom for the ruling. She had left after the first day. And I was glad of that, not because I wanted to see her reaction, but because I did not want to have to manage mine. Outside the courthouse, Farida told me the DA's investigation was ongoing and that she expected formal charges would follow within 60 days. She was right. Philip Ease filed charges of elder financial abuse, theft by fiduciary, and fraudulent property transfer 63 days after the probate ruling. Renata entered a plea of not guilty. Her trial was set for the following spring. Gregory Solari was no longer her attorney by then. Her new attorney was less experienced and visibly more expensive, which is what happens when people become afraid of what a courtroom might produce. I want to tell you about the week after the probate ruling, because that week is the part I think about most. I went to my father's workshop. Renata had not touched it. It was in a detached garage at the property, which was now frozen pending the investigation, and she had apparently decided it was not worth contesting. I let myself in with the key from my father's desk, and I stood in the cedar and machine oil smell for a long time without turning on the overhead light, just the small window light. When I looked at his tools on their pegboard hooks and the half-finished cabinet he had been building and the laminated safety instructions he had written out in his own handwriting and posted on the wall above the main workbench. He had been building the cabinet for Willa's room. It was for her art supplies, he had told her, a proper place to keep everything organized. He had been 4 months from finished. I stood in the workshop and I thought about the 9 years of Renata's practical, purposeful presence, and about the 18 months of documented decline, and about a man who had filed a letter in a drawer because he was worried and did not want to worry his children and was not sure who to trust, and I let all of that be what it was. I did not reach for resolution. Some things do not resolve into lessons. They just happened. And they live in you as the shape of what happened, and you carry them the way you carry any part of a person after they are gone. Clement came over that Saturday. We finished the cabinet together, following our father's penciled measurements and the notes he had left on the wood in his handwriting. It took us most of the day. We were not skilled woodworkers. The joints are not perfect, but the cabinet holds. Willa uses it every day. And somewhere in the county courthouse records, under case number 24-PR-4471, there is a judge's ruling that says my father's handwriting meant what it said. That is the most that justice can do sometimes. Confirm what the person who is gone was trying to tell you. It is not enough. It is also not nothing. I'll take both of those truths and keep moving.